All right, so just want to make sure everyone was able to make that adjustment. And if you can go ahead and mute yourselves, and if you have something that you want to ask, just go ahead and raise your hand. We're going to reserve for Q&A at after I've presented bulk of the information. So if you can go ahead and wait until then before asking a question. One of the reasons why we were asked to do this call was to go over, for those who are in the United States, the letter, the campaign letter for the Congress that we are using as one of our preliminary actions to start putting pressure onto the Department of Justice and the U.S. District Court in Nebraska. What we've seen so far is from the very beginning is some missteps in procedural due process. So we want to try to correct that and see what kind of relief we can get for that for Neil. And the other thing is for those who are outside of the United States, what we want to be able to do is bring an amicus brief. Now, usually amicus brief is used for appellate or appeals courts. But I think in trying to correct this issue, since there is an issue of forfeiture that's involved, and that the process for the forfeiture plan isn't being disclosed publicly, that something be entered or given to the court to let them know that the proper notification and the right to make a claim was not given to those who are involved in contracts or agreements that may be involved with the forfeiture of assets. Okay, so what I have up, hopefully you can see it, is cause of action advocates. There's an example of an amicus. So I'm going to begin where we are right here. This is based on a F.O.I.A, a Freedom of Information Act request. And there's an introduction. And this one is dated for 2012. Now this organization is still operating. And one of the organizations, along with the American Civil Liberties Union, that we're going to be contacting, and we should be doing this in a coordinated way, organized way, with as many participants as possible. I know with the American Civil Liberties Union, they tend to favor a class of people over individuals. So us coming together and formulating something in particular is ideal for trying to get members heard. Now, I imagine we do have Australia is the leadership for Australia on the call.
I'm not too sure.
Okay.
I'm in Australia, but I'm not I'm not classified as a leader, even though I brought a lot of people in. So yeah,
Hmm.
yeah, I don't know. Yep.
Okay. Well, if you can also leave information for us on the leadership and maybe whatever contact information they've made available to you, preferably emails, because making phone calls is difficult. Zoom would have been a more ideal way of them getting information, giving information to us. That's something that we want to be able to coordinate, seeing that for those who aren't familiar with uh, there's an opposition group referred to as the naysayers, um, Mike G. Deal, Uncensored, and they're beginning um, uh, to release information on the Australian group. So we wanted to be able to make sure that they understood what was going on as well. Right. So, and I'm just going to briefly read this, at least the first paragraph. There are three types of forfeiture processes under federal law that have been used to achieve these means: administrative, civil, and criminal. Administrative forfeiture occurs when a federal law enforcement agency with requisite authority seizes property in the course of an investigation. The seizure must be based on probable cause that the property is subject to forfeiture. The administrative forfeiture process is non-judicial, meaning it is uncontested with no involvement of state or federal court. With civil forfeiture, the federal government files a civil complaint in rem against the seized property and bears the burden to establish by preponderance of the evidence that the property was derived from or used in the commission of a crime. Civil forfeiture, like uh, much like administrative forfeiture, does not require criminal charges or conviction of the forfeited property owner of charges supporting the forfeiture in order for the government to prevail and seize the property. Criminal forfeiture, on the other hand, is initiated by the government only after the property owner has been convicted of charges supporting the forfeiture. The United States Department of Justice Asset Forfeiture Program initiates all three types of forfeiture processes. Now, I'm mentioning this because what we see happening is that there's a time requirement for the process of forfeiture. And I'm just going to bring that up here. So examples of types of services, seizing or seizing agency. And I want you to pay attention to the amount of time. So in some cases, all these different services have to be performed before they can begin to even seize property or freeze bank accounts. So 2 to 4 months or longer for businesses, logistic services, 3 to 6 months, uh, animal care, I think that's NA. In this case, 1 to 2 months, 3 to 4 weeks from the date of request or return of information, lien search and appraisal information. So what we're not seeing is within the public record is the plan that is supposed to have been initiated prior to the forfeiture and seizure. The reason why I mention this is on the unsealing of the indictment. So the indictment was sealed on the 14th of June and unsealed on the 29th of June. So there's 15 days. So as far as the criminal complaint or anything having to do with the investigation that led up to the grand jury indictment, there's no information on that. Also in the public record, and these are some of the things that we use the FOIA, the Freedom of Information Act, process, and also we include our findings or the results in an amicus brief, because what it amounts to is by doing it not incorrectly, it actually violates one or more of his civil liberties, which is grounds for mistrial, at least for a new trial. That's part or a type of relief. There might be other reliefs available. It depends how gross the negligence is. Okay, and this is actually out of their manual. So this is the asset forfeiture manual, policy manual for the Department of Justice. So why is this important? Because on the indictment itself, what it lists is 10,000 victims. Okay, that relegates us to very little to no impact or influence on the proceedings. To have made that without making any inquiries as to what the nature of the transaction was. Actually, we have Maria Simmons. You have a question?
Hi, good night. It's not a question. Some of my partners from Trinidad, they're waiting to get in.
Hey, Maestro, could you clarify something?
Sure.
Does the freezing of an account constitute forfeiture?
Well, yeah, because it's restraint or forfeiture or seizing. So
Okay.
if they restrain you, it's the same thing as a forfeiture. So it's either in the process of being forfeited, or it's not available. So if it's not available, that's definitely interfering with.
Technically, it is forfeiture if it's not available, even if they haven't really taken possession.
Right, and that's going to happen in most cases, especially with this particular case. You're talking about bank accounts. Obviously, they can't, take actual physical possession of the account or the real estate, the properties, maybe the vehicles, but in other property listed, they could. I don't see how they were able to do that on a short period of time, make arrangements, because you're talking about over 40 vehicles, maybe they were able to do that. But the whole issue for us is not so much the properties, although it's definitely related to the overall activities of the company itself that give it its market value. It's really the amounts that are inside the bank accounts. They don't really, and they couldn't really give the full bank accounts or the names on the accounts, or whether or not there was a personal name, whether it was a business name. These things were not mentioned in the indictment or any of the documentation that is made available to the public, and for good reason. And they could redact it, so people can get an idea in order to categorize, the accounts to see whether or not by the type of account it is, they could assess whether or not it was, transferring, funds from, say, Banner Op um, uh, or from other accounts into Banner Op, what have you. So that, we can't see either. So, in not being able to see it, I'm wondering what type of evidence they actually showed to justify the seizure of those accounts. And it's not even the seizure or the freezing of it, it's about the process. They're supposed to show, just like under a regular warrant, under Fourth Amendment, they're supposed to be able to show the reason, the probable cause, and the connection evidence, showing evidence of its connection. And I just don't see it being 100% that all these accounts were involved with the actions that are mentioned on the indictment. In fact, the amounts that we calculated was less than 2 million out of the 45 million that were in the accounts. 2 million that were actually involved with the allegations of wire fraud or money laundering. So they're just right off the bat, it just doesn't seem correct. But what it's caused is the inability to choose representation or counsel of choice, which is very important, because what ends up happening is that if he's appointed a public defender, and that public defender's interest level is going to be at a certain level, depending on their caseload, depending on time availability, the notice given, all sorts of different logistics that will affect the effectiveness of counsel. It's not like a dedicated firm. So that's one of, but also there's a natural conflict of interest when you're dealing with a public defender's office as well, that has to be considered. Because most of the time they're also dealing with the prosecution on deals, or, they have what they call ex parte communications concerning the case without the presence of the defendant. And that happens quite often. There's not as much scrutiny paid, or there's the protocols of receiving information or giving information isn't as restricted and protected as it would be with the counsel of choice, which affects the overall quality of the defense. So so seizure and restraint is what we're talking about here. Now, this isn't common. This has been going on. This is mentioned, from 2000. This PDF from this F.O.I.A. and Amicus Brief goes back to explain that's from the 1990s. So ever since they started using this approach, they've kind of used it more liberally and more often. So from the 1990s, mid 1990s. So it becomes something that they do, not necessarily that's warranted by the case itself, but part of their procedure. which, when you do things often enough and you're not thinking about what it is that you're doing, chances are mistakes are going to be made. And on the criminal level, you're talking about RICO statutes, you're talking about drug enforcement. So there are differences, with identifying properties in forfeiture or monies in forfeiture. It's obvious that the gains that are seized, or the property that's seized is the gains from an illegal activity when it involves drugs, but not so much when you're talking about wire fraud or instances alleged to be wire fraud or money laundering. Money laundering went hand in hand with the RICO statutes for drugs. So it's not as clear and definitive with these banking white collar crimes, I guess you would say that. So they're kind of using the same process for distinctly different activities, two distinctly different activities. And since they have a general wire fraud claim and 2 counts of alleged money laundering, it falls under their general definition for seizure, cause of action for seizure, probable cause. And this is without them proving allegations. What it amounts to is the possibility of just, outright stealing assets just by bringing charges. Okay, so let me just pause here and take any questions that people might have.
I did have a question, but while I was waiting, I already solved it myself. Thank you.
Who's this?
Chris from Australia.
Chris.
Yeah, I was just wondering if that was available, the PDF file, but I just typed it in. It is.
Yes.
Yep.
Yes. Yeah.
Thank
it's
you.
widely available. Yes.
Yeah. Keep up the good work, giving us the information.
Thank you. Maggie Carazana. Caranza. Maggie.
Hello.
Yes.
Yes, I just have a question. Just catching up because obviously there's a lot of things in process already, and I'm just surprised to hear that Neil does not have a private attorney. Does he have a public defender?
Yes. And, these are some of the questions that we're going to be discussing as we start working on the FOIAs and also the Amicus Brief. Because in his particular case, he actually has the director for the Public Pretender's Office, the Federal Public Pretender's Office, representing him. The director of the office is he does have some also another associate public defender, but Mr. Stickman is actually the director of the Federal Public Defender's Office, which raises 2 questions. Why do they need the director? Are they shorthanded, on public defenders? Or is there, some strategy? And like I had mentioned, the conflict of interest that naturally occurs between prosecution and defense especially when it's a public defender's office with ex parte communications. So whenever they're looking at plea agreements or arrangements, they're kind of throwing ideas back and forth, but it becomes more of a conflict of interest when both are have an interest in representation and obligation to the court, and not necessarily the defendant.
Okay, thank you. And but it sounds like he's out on bail, correct? Because
No, he's
according
not.
to- oh,
No,
he's not. Okay.
He's still being held. And that's been the case from the very beginning, because they froze all of his assets. Not some of them, all of them. So, and this is why we're covering the issue of asset forfeiture. Now, there is a case. It's called Lewis versus the United States, which it talks about in this particular brief, in which someone's mic is open. In which they talk about tainted versus untainted. That means ones that are obviously involved within the crime, and then others that are not. And the use of that in order to specifically get representation is the big question. Why, out of 45 million in various bank accounts, isn't there enough for him to be able to get counsel of choice? Which is a Sixth Amendment violation. It's the reason why the Supreme Court ruled on it the way that they did. Well, I'm not gonna spend too much time on this, because when we start getting involved with the actual FOIAs and the actual amicus briefs, we'll be able. Hopefully, people will have already had information to kind of review, to give them a sense and idea of what type of contribution they'll be adding, and what they should be considering. I'm not going to go into an academic discussion about it here. Let me see if I can. Now I'm going to be placing for members to go through their leadership to get access to some of the public documents. We want to control the information only because we have opposition, some disgruntled former loan partners that have decided that they've lost patience, and they were going to help contribute to bring these public agencies in and give testimony or give evidence. So what we're trying to do is reduce the amount of information we give them. I'm just waiting for this. So this is on a Google Drive, and I will be putting the link on the site so people will be able to access it. But certain things, but there will be other files or folders that you would have to go through leadership to get. Okay, so there's the investigation, there's courts and amendments. Let me just mention something. Since most of the people who are on this call, the reason why we set this call up was to give them an option to participate because they weren't able to do the congressional letter because they were from outside of the United States. But I'm going to cover this briefly. Well, this is a perfect time now that you got the sound.
Okay.
Is to go ahead and address your group and welcome them.
Okay.
Maybe an explanation of some of what we had discussed and the purpose and the reason for today's meeting.
Right. Well, thank you so much, Dino, and thank you, everyone. I know I'm very happy that we all got here together. God bless you, Coach Kohler, and all the leaders, Mary Lou, Linda, the different teams that are here. We are in a very, very sensitive moment that demands that we all participate. We cannot sit back and just watch the process and hope. It demands action. Like Dino was saying, we need some pressure. It is so funny. I had a conversation a couple of days ago with Dino and Kim, and very, very refreshing conversation. And it's amazing that the same three things that I had in mind, Dino actually said, Neil, were you in my living room? Which is dealing with the freedom of information, the process of writing to the Inspector General for the court, the federal court, for the DOJ and the Security and Exchange Commission, and also for the Amicus Brief that he had mentioned this afternoon. And I already took the time, about 2 weeks ago, and I wrote to Judicial Watch. I didn't want to mention it on the last call, but I needed like Kim said, Dino is the man with the substance to kind of nudge them along. I haven't heard him mention about the ACLU, and we need to do this. We cannot sit back. They have a history, as they illustrated in some letters that I sent out to a number of persons, and the judges noted it, that they have a long history of dragging things into years. If we don't become proactive, trust me, that's what they're going to do. So the purpose of having this meeting is that we all get involved. We need to raise the signatures. We have a goal of 10,000. The best way to do it, we're almost close to 2,500, is to break it down like how do you eat an elephant? One bite at a time. So when we hit 2,500, our next goal should be, we want to hit 5,000. So among our group, we say, okay, 2,500 is all we're going to do. What are you going to do? And we break it up. And before you know it, we had 5,000. Next thing, we hit another 2,500, we had 7,500. We hit another 2,500, we had 10,000. It is very doable. That's one of the things that are very, very important. It's very important that they also hear, as Dino has indicated, from the internationals. And that's where the Amicus Brief comes in. So the court gets notice, and it put them on notice that there are people involved. We are not victims, we are victors. We are literally stating our position that we have, I like to call it a pecuniary interest. And we're not some bunch of fly-by-night, we are very serious people. So I think tonight is very important that we get the word out, we become very proactive, and we can't just sit back and wait for one person or anybody else to do it. We need to all band together, those who can do some stuff. The letters that need to be sent out to those that are in the US, make sure you get letters out to the Oversight Committee and also to your representatives, and follow the process that Dino has for the international. I believe that as we band together, there's nothing that can be withheld from us, right? That we work together in one unit with pressure on those different points, especially with the Inspector General for the court. In other words, we put them on the run. We have them taking notice that we are not here. We're not a bunch of fly-by-night. We are not victims. We are victors. And as I told Dino and Kim the other night, we want to get the coal so hot in their hand. You know, how long could you hold hot coals in your hand? You have to drop it. Enough pressure gets the job done. So that's what we're doing. We're laying the foundation to make sure that it's done. And I am deeply honored for the work that Dino and Kim and a number of leaders, Mary Lou, Coach Kohler. I'm very, very impressed by you as well. And of course, the leaders like Linda and all of you that are here. We can make a difference, but we can't do it by sitting back. As the judge noted, she said you had a case here, but sitting around for almost a couple of years, and I'm not having it, right? She's aware of that. And of course, we know one of the big problem that they're in big trouble, and they have a habit of doing it, is making a lot of error in his statement, like saying that Neil had 10,000 victims. We don't have a contract with Neil. So where did they get that from? So this is the purpose of that amicus, to correct all of that. Dino is the man to put it all together. And I am very happy to do my part in whichever way that I can. God bless you all. And we will all win together. We are victors, not victims. God bless you.
Well, thank you, Neil.
Back to you, Dino.
Thank you, Neil.
Yes,
Thank you.
welcome.
Neil, thank you for that, for those words. And I just want to share with everybody here that the depth and the height of your passion for this, involvement in this, will depend on the depth and the height of your understanding. And the quality of your understanding on what's going on, what we're trying to do, will really rest on the quality of your questions. So please, if there's, don't consider us dry or anything. If there's anything you don't understand, there's so much that I have learned. And I realize this is something that we need to have a good understanding of how it works. It's very informative, Neil, what you just said, that the judge said they've had cases just sitting around for years. That's because there's nobody putting any heat on them, And the one thing we know is they have never shown us any reason, any point that please mute that person out. They have not shown us that this man, Neil, could not accomplish the task. They found a ton of tens of millions of dollars that they froze. So obviously it didn't run off to some holiday with it. They found assets. It's all there, and it can all be explained. And it just seems like their interference could be the thing that doomed this. Let's forget about all the other naysayers who don't know what they're talking out of the side of their mouth, their head, But we ask questions, please. Ask questions. If there's anything you don't understand, the way you're going to get it is ask questions. The quality of your questions will depend on how well you understand this, that will cause your passion for this. Because just think about what we were promised. The amazing life we were all looking forward to. And the only thing that has hurt it almost immeasurably right now is this action by the governments. Period. That's the only thing. And the thing is, this metaverse thing, currency reset, global transaction changes, it's going to happen with or without us. But we got in line to benefit from it, and they're trying to kill it. Just understand that. Just understand that. There's nothing else that they have shown us. If this man did something wrong, okay, go ahead, show it to us, prosecute him. But if he hasn't, don't injure our prospects. Just think that way, everybody. So back to you, Neil. Thank you for the wonderful job you do.
Thank you, Coach Kohler. And I know we have quite a few internationals on the call. Apostle York, he's all the way from Dominica. I know you had a number of questions. Could you unmute and come on and you can ask Dino your question? Are you still there, Apostle York? And I know also Monique had some questions as well. You want to ask your question, go ahead. Unmute one by one. Go ahead, Apostle York. Is he still there? Apostle York, are you still there? I'm looking for him. Okay, while he's doing that, is Monique still on the line? Let's see, Charles York. All you have to do is hit on the button, Apostle York, and unmute. Right, you're still there. All right, while he's doing that, anyone else? Monique, are you still there? A number of people on the Queen. come in one by one. But that's the purpose of our call, is to question and answer. All right, you don't, like a coach said, Coach Cole has said, it's going to be based on the quality, I believe, if I heard it right, the quality of your question. So let's have some quality questions. Your question is going to answer questions that other people have. Don't be shy. This is our night. And Dino is here and all the other leaders to answer the question. Go ahead. Okay, we have a Penny Wilson. Who's up first? Penny.
Hi,
Go ahead, Penny.
I have a question. With all these allegations that they're accusing Neil of, and not to speak negative, if he's found guilty, where does that leave the deal? Do that mean that we have all lost out, or do that mean that someone else step in and take over from where Neil left off at? And if they do find him guilty of anything, is there going to be an appeal?
Dino?
What's interesting about that question, thank you for the question, is that Neil wasn't alone in this to begin with. There was a board. So for whatever transaction he might have done that would be considered more money laundering or even wire fraud, he could be penalized for that, and if he's found guilty of it, if they show the evidence. But how does that affect the interest of many other people? It shouldn't. Because what we're talking about is contract law. What we're talking about is agreements. One of our issues of contention with the Amicus Brief and the FOIAs is the jurisdiction of the government to interfere with private contracts. They're not even saying that he committed fraud against the government, which is really what their jurisdiction is. So if there's a program that Congress votes on and funds and for a particular department, CARES Act or COVID relief, well, then they have obvious jurisdiction over that. But what you're talking about is a claim of one individual expectations, or perhaps a contract or whatever, that created a transaction between two banks. And transactions are not that abnormal. I mean, especially between two entities involved in regular transactions. So for it to come up and for them to determine that these specific transactions, out of the many transactions that happened over the years between these two entities, was somehow crime, well, there would have to be some extraordinary circumstances behind it. And if there's a complaint, well, then the complaint has to be first, the jurisdiction of most complaints between individuals concerning contract law is the civil courts, and usually the state courts, not the federal courts. So how this became of interest is based on the wire fraud claim, and it's just an allegation. It's a very broad term that's used. That means anything that includes electronic device. So anything in the last 40 years that any industry's ever used, or any person's ever, put on their laptop or their cell phones, or is subject to this type of scrutiny. So, it's really hard to say that there's any guilt.
And no, I'm not asking, not to break you off, I'm not asking for you to tell me whether he's guilty or to determine.
I wouldn't try to do that. There's not enough facts. What I'm saying is that what you're saying is you're concerned about your interest in this, and you should be. and whether or not there's, still the ability for whatever interest and investment that people have made into this particular project, whether or not it's going to disappear. I don't think so. I think those from the very beginning, there was remedy already considered, if not, directly spoken about, and ongoing. And I believe with the Mike G deal, it was he was talking about a specific foundation that he was forming. He had a special name for it. Well, what was that foundation?
It was called the
believe,
bamboo,
yeah,
something
yeah.
bamboo. Yeah.
Yeah,
Yes.
the Bamboo Trust. So it wasn't just, limited to that. But as far as this particular platform is concerned, you can't unring this bell with metaverse. And for people should take the time to actually look into the components that make up the metaverse platform and realize that there are a lot of companies that could come together separately and join together in an enterprise in order to develop it. In fact, some have what they call disruptive technology. So I believe, based on my understanding, my research, that this deal is going to go through, regardless of whether or not it has Neil involved at the head, of it. But even then, the person who just asked the question, what's your name?
It's Penny.
Penny. Okay, so Penny, how familiar are you with metaverse?
I'm familiar
with V-Market, what it's bringing.
No, I'm familiar with some law, but not a whole lot of law. I know how one reason why the court can get involved and what's not, and this can go either way. I understand that they have to find evidence and all that. But my question mainly was just to ask if, for whatever reason, they find him guilty, then would the deal go forward? That's really was my question in regards to that, whether, because I know it's more than just Neil, is you got a board of people and
Right.
what's not. And I understand from the beginning, they said that we can pull out, and I don't want to do that. And I understand that they said we can get what we put in. I want the deal to go all the way through, of course.
Well, the
And
deal is
that
going to go through, whether or not it's with V-Market or any other company that's involved with this type of technology. Well, that's yet to be seen. Because there's so many X factors here. On both the seller and the buyer side. There's just so much that's not known.
If I may interject a little bit.
Sure.
The last meeting that you had, you mentioned something called torturous. I don't know if I pronounced it, interference.
Yes,
and the fact that
torture.
we the people, this is something everybody have to get.
That's
We have the
tortious.
Tortious, right? It's
Yeah.
tortious, interference. Let me get it right. Okay.
Mhm.
We have the ability as a people to contract unlimited with each other without interference. No entity can enter into a contract without our consent. We haven't given them any consent. What are they doing in our contract? They have interfered, if I may use the right word, in our commerce, in our trade, without our consent. They're like a bully that bully his way, and there's a penalty for that. For any entity that step into a contract in which they're not a party. Did I hit it on the nail, Dino? Dino, did I hit it on the nail?
Yeah, that's exactly what we're talking about. That's freedom of contract, and that's inalienable. We don't look for permission. It's not something that can be taken away or given or transferred or sold. So that's why the main topic of everything that we discuss is civil liberties, because those are immutable. No matter where you are on the planet, they're immutable.
Let's take the next person in the interest of time. I had and Zinga, she dropped off. Let's take Belinda Massey, unmute, come right in. let's move along. What's your
Thank
question?
you.
Okay. Belinda,
Yes.
go ahead and ask your
Um,
question.
it's two-part. I wanted to know, I know these questions may have been answered, but I wasn't on here. What is the basic reason they arrested Neil? And why does he have a public defense and not a hired lawyer? Because from my understanding, I could be wrong. Public defense would mean that he didn't have the funds, or why did he choose that? So that's my two questions. What's the basic reason they arrested him? Because I really want to study that, whatever that answer is, and
Okay.
why
All
did he
right.
choose the public defense?
Okay. You and Zinga, you're going to be next after her. Go ahead, Dino. Go ahead.
Okay, so the charge that he's brought up on is called wire fraud. And I just briefly told you what the components, it's any transaction through the banking system, which is under the central banking system or the Federal Reserve banking system that comes under their jurisdiction. That they deemed to have violated some code or regulation. Now, we don't know what that is because it really hasn't been specified. There have been, like in the indictment itself, it shows 3 instances of wire fraud and 2 instances of laundering, money laundering. But these are general, and there hasn't been a criminal complaint. There hasn't been documentation of the investigation leading up to the grand jury indictment. And there hasn't been no answer from the defense, to these allegations either that is being made public. So there's a few things that still has to be done. As far as getting information, FOIAs are a way of getting that information from the FBI as well as the Department of Justice. And that's part of what we're here to discuss doing. And what was the second part of the question? You were talking about.
Part you was asking, yeah, why does he have a public defender?
Okay,
Right.
because yes, because his Sixth Amendment rights were violated. So he was arrested at 6:30 of the 29th, 6:30 a.m. And that's when they unsealed his indictment. That's when they picked him up, and then they brought him into the California U.S. District Court. Now the processing there, I don't know what time it actually took, but I imagine it took an hour or so to get him processed through, and then also scheduled for a hearing. Now that hearing, so during this time, he was supposed to have had counsel. So that's the right of counsel, and it's the right of choice of counsel. That means that if you're not indigent, he didn't realize he was indigent until they informed him that he had all of his assets frozen, and they were on a forfeiture. So he didn't, and there was nothing that was left to him to be able to utilize. And he did have on his, and I'm going to go back and I'm going to show this. He did have on his, on one of his documents where it was processed by the FBI, the arresting officer, that he did have an attorney. But his attorney also had a number that indicated that he was in Virginia. Even though it might have been ported, he could have been in California. Either way, it wasn't enough time for him to have the attorney come down and represent him. So he did not have a choice. of counsel. In fact, they said he was indigent, but he didn't qualify for prosecutor. I believe that was in his hearing from Leavenworth, his video conference hearing for the Nebraska U.S. District Court in Nebraska. He stated he didn't have an attorney because they told him that he didn't qualify for a public defender, and that and he said, but they had frozen all of his assets, so he doesn't know how he didn't qualify. So that was one of the things that was spoken of in that arraignment over the video conference for the U.S. District Court of Nebraska. But that also begs the question, how was he able to get a public defender in California for his arraignment? Because they already knew that he was going to be indigent, because they had already known that they were going to freeze his assets. So, and that's part of what the FOIA is designed to do. And presenting the answer to the questions that we ask then becomes the amicus brief.
So bottom line, they asserted he had a lot of assets, so he didn't qualify for a public defender, and yet they froze the assets, so he didn't have any money to hire a personal attorney.
Right, which is this is a major violation, because under an indictment, usually in an investigation, there's a period of time where you don't need a lawyer. You know, during an investigation and questioning and, you know, what have you. And then you can ask for your lawyer. You have to request a lawyer, and that's Fifth Amendment right of due process. But when you are, when you've been indicted by a grand jury and charges have already been, you know, placed on you, the Sixth Amendment automatically attaches. That means you don't even have to request one. It's automatic. They can't speak to you unless you have an attorney, which is the reason why, even though he had his assets frozen and he didn't qualify for a public defender, there was a public defender at the court.
I know. Yeah, go ahead.
Before you move on, if I can just clarify one thing. This whole thing stopped because of Neil's arrest, because of the government intervention and direct action with Neil. That's so we see facts, and we look at facts. We see the filings. That's what this is about. This is not about whether Mike G said this or Mike G said that. Mike G said, listen, they're dealing with him on that end about all of that, and obviously, he has given some kind of answers that allows him to stay home. We don't know what that is, but as far as this whole deal being able to happen, has to do with Neil being free to make it happen. The fact that they found tens of millions of dollars really means that whatever monies that we found out got to him, right? And we got it to him through Mike G. Maybe that's why he's still home, because he followed through. So now the question is, what we see on the, so when we talk about this, is not to explain what Mike G said or what Mike G, that has nothing to do with Mike G at this point right now. There's a lot, but you know what? He's going on with his own issue, and maybe sometime down the road we'll understand a little bit more, but the bottom line is this. The whole show stopped with the arrest of Neil. The question is, number one, why? Number two, is he getting a fair shake? Number three, what happens to the hopes that we had. That's what this is all, and what are we going to do about it to make sure he gets a fair shake? Because the only way we can get the best outcome out of this is that he gets the best outcome out of this situation. And they haven't shown us anything yet that he was incapable of making this happen. Those are facts. Whatever else that we read about Mike G, that's not for discussion on this forum, but this is the Neil Watch. Not that we don't care about it, but we don't have any other facts other than what he said. Everything else will be conjecture, innuendos, and we don't want to deal in that. So I hope you all understand. We are all concerned about that, but it's not the point of focus right now. Go ahead, Jim.
Yeah, thank you so much, Coach. And now we'll move on to Jayan. Mackie, could you come in quickly, and we kind of keep it to about 2 minutes, everyone, so we can move on. It's getting top of the hour. Jayanti Mackie, go ahead. And Dinga, keep coming in and she's leaving out. Go ahead, open up, unmute. And next would be Peter, real quick, and then Andrew. We kind of keep things within about 2 minutes quickly.
Can you hear me?
So we can move on. Yes, go ahead.
Okay. From the day one after I quickly browsed through the indictment, I've been saying this case can be thrown out by any decent lawyer who reads what's there. Because 10,000 people did not complain. And we did not even have an contract with them. So right when the only other thing there was there were no such thing as buyers. I don't know whether it's been proved those buyers are there or not. Has anything been proved? There were no billionaires and there were no buyers. Has anybody proved anything on that point?
Okay, should I be answering this?
Go ahead, Dino.
Okay, okay. One of the things that is going to come up a great deal is non-disclosure agreement. Okay, so the non-disclosure agreement hasn't been disclosed to us. There are only certain people who have received that as to the existence of buyers or how it's, the deal was actually structured, the specifics. People keep on asking for specifics that the non-disclosure is designed to protect. So it's hard to answer
where are
those
these
questions.
billionaires? Why aren't they coming and protecting him?
Okay, again, when we talk about non-disclosure means not to keep information away from you. It's to protect the interests, and those interests vary. But also,
here is a sacrificial lamb sitting in the jail for all these months, and
right.
Nobody cares.
Well, it isn't that. Okay, so just recently, Elon Musk was in the headlines because of the SEC and the consent judgments. Okay, so and also there was Mark Zuckerberg. So these are the two most well-known within technology, richest people, and yet the SEC is capable of interfering with their businesses and interjecting. So there's a reason why these buyers would not be becoming involved. It's because they don't want.
Because all this thing is globalist. They don't want all of Neil's stuff to come out.
Right. So if I know that if I mention or I offer assistance, and the question is, why is this person assisting? Let's launch an investigation into this person and see what their interest ties could be in a connection with this case. And let's go ahead and start sending out subpoenas for inquiries. And that generates unwanted attention and interest in their business. And not to mention,
I understand that.
Right.
But these were the people who were willing to pay a huge amount of money to get his technology.
We're just talking
and
about. the legal implications and the legal aspects of this, not the moral, not, you know, what's right and what's wrong in the sense of morality.
All right.
Well,
Neil has pleaded not guilty, correct? What have they got against him that proves that he's guilty?
wire fraud charges. So banking regulations cross state, that comes under the jurisdiction of the Department of Justice. So and
I don't know what a wire fraud is, so I can't comment on that.
and that's what becomes important. So here's the thing, and I have information pertaining to wire fraud. I'm going to be posting that. In fact, it should be also on the site in one of the blogs that I've already done. There's a video on wire fraud. But the point is that everyone here is going to be educated in areas that they had no interest in before, but have become interested in because of the crisis that's being created by this action being taken by this public agency. So now you have a learning curve, and you're responsible to make that curve. But
Okay.
we're going to be assisting as much as we can.
What's his name? Jackie or Jack? Do you know?
Okay, so
Go ahead. What were you saying? Who is this? That is it? You were just saying. Can you speak up? Whoever just made that comment about
Oh.
Jack.
Okay. Yeah, I'm Chris from Australia. Yeah, I was just wondering who that person was. Okay. Look, to be honest, the average person in the street would have no clue what an NDA is. And why I'm saying that is the company I'm involved with, we had to sign an NDA, which means we cannot promote another company, blah, blah, blah. And they said, oh, that's rubbish. That's nothing. So the average person does not know what an NDA is. And why, if I was a billionaire supporting this, why would I lose my reputation? Because everything will be out in the open, okay? That's the reason they've kept quiet. Okay, now some people are saying this is hogwash because what we got in the palm of our hands is absolutely unbelievable, and the average person sometimes can't see past their nose. Okay, I'm not being disrespectful of anybody, but a lot of people, our CEO for our company is a Ukrainian locked up in Russia for 2 complaints, as far as we know. Okay, so I'm really thank you for saying you need 10,000 signatures to get the case rolling. So I already sent messages saying, hey, get your act together. We need at least 10,000 signatures for his case to go to court. So thank you very much for your time. Unfortunately, a lot of people really, as you were saying, need to really think before they ask the question. Okay, so
Thank you. Thank you so much, Chris.
yeah, thank you.
We appreciate it. Thank you. And next up, in the interest of time, let's make it quick. Peter, go ahead. Peter from Australia, the Raging Bull. Go ahead.
Yeah, look, I'm just going to be real quick. We've got
Yes.
10,000 people.
Mhm.
What do we need to do to get Neil, his attorney, to represent him?
Go ahead, Dino.
Okay, so part of what we're doing is we're doing the FOIA. First of all, we're going to start asking questions concerning the asset forfeiture. Then we're going to also put in a FOIA.
Somebody need to mute. Somebody need to mute themselves.
Right. Okay. So we also need to do a FOIA having to do with a rehearing by the district judge concerning concerning the judgment that was already made in California and then reasserted in Nebraska.
So basically, what they did, and this is not asking for legal advice, just your opinion. What they did in California, was that lawful? Do you know?
Well, yes, it was lawful, but it was conflation. So they use an administrative process to actually violate procedural due process. Since they use the forfeiture in order to freeze his assets, and they also stated that he was not qualified for assistance through the public defender's office. That left them without counsel or the ability to retain counsel. But yet they allowed that condition to exist for at least 2 weeks.
And for this period of time, for the 2 weeks, from your knowledge or understanding, did Neil have any? Did he have any counsel representing him between the time from LA? Yeah.
Yeah, actually, since we don't have anyone that actually has contact with him, that would have, been, someone that he would talk to, that person hasn't come forward. We were not able to assess just, what his discussions has been or what actions he's tried to take personally, if any. But the whole point being is that not having most lawyers and most firms average anywhere from $150 to $250 an hour. So depending on what it is that they're working on, what action they're putting into the courts, he would have to at least have a certain amount of money, I think $5,000 to $10,000 in a retainer at least, to get some just preliminary actions taken. So, and from what I've seen, the public defender has done, I'd say, an expected adequate representation on certain issues, but there have been omissions or the lack of questions on their part too. And that's harder to describe because unless you're familiar with procedures and what the requirements are, you don't know what you're what you've never had. So you don't know that you're missing something because of the omission. Those are harder to spot. But that's what the remedy of the amicus and also the FOIA is there for. We can ask those questions within the procedure of the court having to do with due process and procedural due process and substantive due process.
Right.
Okay, I'm done. I'm going to let you keep going.
Yes,
Thanks,
we have
guys.
two more in the, thank you so much. We have two more in the queue. Dino, will you go ahead and do that? The first person will be Andrew. Come on in, Andrew. Go ahead.
Hey, this is Andrew. Can you all hear me?
Yes, we can hear you loud and clear. You're full of energy. Go ahead, my brother.
Okay, great. I just have a couple of questions. I don't want to take too long. I just remember when I was looking at the Mike G updates that he mentioned something about power brokers coming in and helping Neil with his defenses. And I just wanted to know more about that as much as we can. I'm also very interested in the board of directors. I would like to know what they're doing behind the scenes to keep this deal alive, because I know we're all very interested in that. And that's basically my question. I just want to know more about these power brokers. Like I remember Steve Mnuchin, he was supposed to have written the bylaws for the deal. And I just remember that the Department of Homeland Security was supposed to be involved. So I would just like to know more about those entities and the board of directors, if you will. Thank you.
Okay. Well, let me just go ahead and just mention to people the reason why this call is being done is for actions that can be taken by those outside the jurisdiction of the United States. We did have a letter campaign writing to Congress and congressional members of the Financial Services Committee. But for those who are not in the states, there are other options such as the FOIA and also the Amicus Brief that we're discussing. The updates, I got to be honest with you. I have a lot of experience in sales and marketing, and I just never paid attention to them. I'd be the wrong person to ask because it is a story. And since it is also a narrative that was developed in order to avoid specifics or, facts covered by the NDA, it'd be hard to say, who these people are.
Okay, let's move on. Thank you, Dino. We want in the interest of time. The last person in the queue would be, thank you, Andrew. You can pull your hand down now. And next person would be Leslie. Go ahead, unmute. Bridge loud, go ahead. You need to unmute, Leslie. Unmute. Okay,
Hi,
go
good
ahead.
night, good night.
Good night.
Hi,
Good night. Good night.
First, I have three questions. First, to begin with, what it is that we need to know or do to move forward here now, and the next question is, before you said that you all could, the other persons who is involved in the deal the deal could still go through. What I want to know, what is to confirm this could go through still, and what can we do now to move forward? Because, that's where we want to know. We want to know what to do now, because we are just waiting, as you say. Everybody's just waiting.
Go ahead, Dino.
Oh, again, as far as updating people, on what's been going on with the deal, I can't really say because there hasn't been much in the way of updates on the deal from Mike G. I can only tell you what's been going on in the courts and in California and Nebraska, and some of the activity of independent agencies regarding this case. So what people can expect, well, that all depends on how much they've actually understood the information. So it would be very hard for me to say. Everyone just has a different perspective on this. Some are optimistic, some are not. All I can say is that all the components necessary for this deal to go through still exist.
Yeah, but even though you say it could still exist, tell me, you're saying it could exist, we could still do this, but what we need to do to move forward, to get it to close?
Dino, if I can just interject.
Sure.
People change things. I didn't say a person changed things. People change things. Politicians listen to people. Politicians are the ones who control those in the legal system, the SEC, the DOJ, and politicians listen to people. So the first thing is generate a lot of interest of like-minded people who understand what's going on, who are passionate about doing something about what's going on. Like we started this the petition. Okay, we should have had already 10,000 people. This is a body that could at some point be led in the direction of a class action activity. But you need the bodies, you need the people, you need the minds. So it's everybody, that has to participate in understanding what's going on. We can show you from the legal point on what's going on, because we send people to the courts to collect the papers And we put all the information on the website so that people can listen to facts and not stories, and be motivated by facts and not stories, and then understand why we're doing what we're doing. Because for us to have the best outcome, Neil has to have the best outcome. Now, mind you, that outcome could be that he goes to jail if he did something wrong. You know, when we're not just stupidly saying whatever, but we know what we see right now. We know what we see is going on in the courts. And we know if nobody speaks up, nothing good will come out of this whole deal. And the dreams, the aspirations, the desires that we all had will die. And the whole system will still go on. Metaverse will thrive. Crypto will thrive. AI will thrive. The change in the whole financial reset of the financial currency system, it will happen. Fiats will go down, but we will not benefit because they interfered and we were left out of it. And so this is why we want to, eyes wide open, look at what's going on and get involved. Without people, nothing happens. Get involved, get engaged. Though for those who are outside of the country, we've talked about the Amicus Brief. You don't understand what that is? It's on the website, and I think he has mentioned it. For those who are in the country, we talked about the campaign. So those who have stewardship over the DOJ and the SEC, to write letters to them. And we've shown what those letters should look like. So what should we do? These are the things that we should be doing. We should talk to other people and slap down all these stupid nay talkers who are just talking out of anger. We understand they're angry, so are we. We understand they're disappointed, so are we. But what they're doing is unproductive. What's productive is to say, I love your question. What can we do? And that's part of what all this is. And our goal was to reach at least 10,000 people. You know how massive that is? We have more than that.
Yeah, absolutely.
One of our group's rosters has over 14,000.
Mm-hmm.
So we need to reach them and get them to understand this is no joke. It's going to happen with or without us. And right now, our situation is being messed with. And we need to come together with a voice. We talked with a sitting judge who said, you don't want to be victims. You want to have standing.
Mm-hmm.
And that's what we're talking about here. But you can't have standing if you don't organize. It's not going to happen. And to organize, you have to have knowledge, you have to understand it, and then we apply wisdom. And that's what we're planning on doing, what we're working on. And we just thank God that there are people here who have a very good understanding of these civil liberties and what we can do about it. So what can we do? Get involved, get engaged, go to the site, write the letters, fill out the petition, show up on the calls, talk to other people, tell them to search out the truth and the facts, not just innuendos and angry people throwing all this kind of nonsense around. That's what we can do. Become a very, very powerful entity that will have standing and advocate for our own selves. That's what we can do. Back to you, Dino.
Can I interject something here, Dino?
Yeah, go ahead.
Okay, I was at or on the Zoom meeting of the initial appearance that Neil made in court in Nebraska. And on that meeting, at that meeting, he told the judge that he had not yet had an opportunity to speak to his attorney. Now, I don't know if that means his attorney in California when he was first initially arrested, or if that means the public defender that was to represent him at that hearing in Nebraska. But at that time, the judge decided to extend that hearing date until September 20th. Initially, she said 90 days, and that Neil's attorney said they could get to it sooner than that. And she asked the DOJ if they agreed, and they said, yeah, we could do it sooner. So they only made it 30 days, which made it September 20th. For whatever reason, there's been an extension of 60 days on that hearing. So he hasn't even had his initial hearing yet, his preliminary hearing. It has never been taken into account yet that he has a right to say anything in his defense. So whoever postponed that hearing till November, sometime in November, probably the 20th, if it's exactly 60 days, has postponed that opportunity yet again. So whoever at the time his attorney was, he got a chance to speak with him for 20 minutes during that hearing process on that morning. But who knows how often he's had a chance to speak with him since, because none of us have any inside information into that. We don't know. None of us have any connection in that regard. And everybody that I'm trying to talk to doesn't want to commit to anything for fear of putting themselves in some sort of legal jeopardy. So at this point, other than getting together a group of people, and I haven't seen that petition that is being sent around to be signed on Neil's behalf, if somebody can email that to me, I'd be glad to sign that. But there, other than that, get together and working together and sending off petitions to the DOJ and whoever else need to see them, there's a question, and she asked it earlier a minute ago. Sorry, I forgot her name, but what can we do? Well, we can get together, but how do we get together? There's got to be somebody that sends out the initiative that says, here's what we're trying to do. And if somebody's got 14,000 members in their group, then they have those emails, right? Or they have those phone numbers. They can send that one email that's addressed to all of them and make that initial contact and get those signatures. The main thing we need to remember is that he's not been convicted yet. He hasn't even been to trial yet. He hasn't even been to his preliminary hearing yet. So his legal rights are being trod on left and right. He's being treated like a terrorist rather than a fraud, somebody that's committed a fraud. So his access is minimal. We have to get around that to do him any good, to do ourselves any good. And I just want to work with whoever I can, however I can, to help make that happen. So thank you, and back to you, Dino.
Hey, Colin, thanks. Thank you for that information, and we'll get with you. And Kim, let's get some information to.
Okay. Well, what I'm doing here is I'm showing the site here.
Okay. Very good.
The congressional letter, the public record, the discovery and disclosure, the case history, resources, the blogs, contract law and NDAs, federal law and courts. All this information is located on the site, including the petition. So, and this is something that we can go ahead and put into into the chat. So if Mary Lou, you want to put in the address, type that into the chat to everyone.
It's in the chat.
It is. Okay. So everyone will have access to that. And I'm just going to briefly, show you the petition for the last person who was actually talking.
That was Colin.
Colin.
Colin Front.
Click on the
Okay.
red one.
Right. But this is an explanation of the petition too. So people will understand, because some people thought that the petition was supposed to be something that freed Neil, although ideally it could in and of itself. It's not going to do that. Okay. So let me pull up the actual.
And by the way, I shared that petition with Neil's attorney. I called him up and he went onto the site. He downloaded a bunch of it and told me he was going to share what the people were saying in his support. He was going to share those with Neil. But as you see, we haven't even reached 2,500 yet. That's why we put this website together, so it could be available to everybody. The letters to the Congress people, it's also on this website. We did a webinar, what was it, last week? Where we went into, even though we already sent out letters, instructions on exact, and PDF copies of the campaign letters, it's all on this website. And we demonstrated it just this last week. So this
we have close to 1,900 that have signed it so far. So we're hoping to improve on that.
The petition you don't even have to download. You just go in there and you complete it online. The letters to the congressional oversight people, we have a page for that. We'll show you that too. And the PDF of the letters are right there. And the people you should send them to, the addresses are right there. So we just need everybody to talk to people and send them here.
Okay, so this is what we discussed on our last meeting, the congressional letter, and also the instructions and composing letter. Some of the statements of video, as well as full instructions. And that was for people who are in the states and that have representatives in their districts. The Amicus Brief is what we were talking about today in the F.O.I.A, the Freedom of Information Act, for those outside of the states to be able to get directly involved. And that's what we've been saying needs to be done. And there's a lot of curiosity. Some of the questions that were asked today are the same questions I've held, for over a year now, since even before any of these issues began to come up. I had questions and still continue to have them now. But the way that I answer them is by, researching the things that I'm not familiar with. And, trying to find an answer, who do I need to speak to? Who has authority in this area? And, just see what it is that I can do about things. As far as the public record is concerned, that's also on. So people want to hear some of the audio recordings. We haven't posted here, along with the dates of the hearings as well. I just wanted to mention that whoever was on the call before released part of this recording to the naysayers group. And this is the type of opposition that we're dealing with. So we have people who are subversive and belligerent and want to see this fail because of some emotional aspect, something that needs to be filled by, some revenge that they believe, or some form of justice that they believe should be served. Meanwhile, we're trying to show people how to work and operate within civics, within the laws of governance, and what their abilities, what their powers are, capabilities are. So while I understand individually how angry people may be, how disappointed they may be, there's an emotional gamut that people run. The one thing that needs to be done at this time is to logically, rationally, objectively go through a process that's going to get results.
Thank you so much, Dino. And in the interest of time, we get into the top of the hour. I'm running out of battery charge. I'm actually outside. We'd like to kind of wrap up a little bit. Last closing comment, and also from Coach and Mary Lou and Kim. We'd like to hear from you as well. And we can crown the call off. Would that be appropriate, Coach Kohler?
Yes, go ahead.
Yes, so I'd like you to take the lead and go ahead and just crown the moment, crown the evening with following that part of it. Thank you so much.
Well, you're welcome. So everybody, we really appreciate you investing some time in this, but just always think in the back of your mind where you thought you would be by now. And we can't just give it up so easily. Think about where you thought you would be by now. And the one thing that has put a stake to the heart of this thing so far has been the involvement of the government. Forget about everything else. This person said this, that person said that person lied, Listen, if anybody lied or whatever, they're looking at them. The authorities are looking at them. But this is the one guy who could effect everything. This is the one guy who could make things happen. And they went and they put a bag over him. And thereby disinheriting us, so to say, of the hard work and the goals, the dreams, the aspirations that we work for. And we know that technology is happening. They cannot stop it. So we can't just give up. We've got to become a powerful people that have standing. And it comes through organizing. And everybody can play a part. All it takes for evil to prevail is for good people to say nothing or do nothing, or people to say, somebody ought to do this, somebody ought to do that. I always say, in any organization that you're in, don't be the person that everybody has to lift. Figure out how you can help lift the load. This is what powerful movements are made from. It's people getting involved, but there's a tremendous amount of talents around here. And I appreciate all the people who have been helping us and working with us. And we thank God for Dino and his wealth of knowledge. I know how much it has helped us at FFG in pushing back with the harassment of the SEC. So please participate to the best that you can and share with other people.
Don't push that.
Thank you.
This is Mary Lou Torres. Hello, everyone.
Hello, Mary Lou.
Hello. Dino, thank you very much for your presence here, that you giving us the knowledge of what we need to do. I have gotten a lot of information from you, which is really awesome, from you and Kim. and I really appreciate that. And I also want to thank Coach Cola of helping also, and we are doing. He's doing such a great job with this program also. So we are really, really appreciate him. John, not John. Neil, thank you very much for putting this together in such a short time with all your members to get into this program. We have what, about 143, the highest. So
Right.
really awesome. So, and to the members, in order to get the petition up there, sign the petition, and also sign in for the updates from this website, nscwatch.com, so that every time Dino has a new information, he'll send it to you via email. We have what, almost 1,800 people that signed the petition, but we only have like 1,100 people that are signed in for the updates. So if you go to the website, please sign in to get your information, because in our Telegram, we're trying to bring all the people to get the information from the nscwatch.com. Because if we're gonna put it in a Telegram, we're kind of putting two wordings, and it's sometimes we're busy and we don't have that time. So you get all your information with the website, NSC website. And also, we're gonna be, we need help from other members. We're gonna put a GoFundMe into for this program, because we have monthly expenses like this website. There's monthly expenses. With the pastors, we have expenses. So just like when I went to LA to get some paperwork, we have expense on the parking, the paperwork that I picked up from the court. So we need help on this. If you guys can donate, we really appreciate it. So we're gonna have the GoFundMe on this website. I believe Kim has mentioned it that they're gonna put it tomorrow. So anything can help, any amount can help. We really appreciate that. All right. And this is for the Neil. This is not a pledge for Mr. G. This is a help to get all what we need to do for Neil. Okay, so thank you very much for being here, and good night, everybody. Thank you. Back to you guys, Dino and
good night.
Good
Yes,
night.
good night. I just would like to say thank you so much, Neil, for coordinating this, and everyone for coming on to this call. This call to action is really what it is. I want to just, and Coach Cola, thank you for your words of wisdom. And Dino, thank you. And I want to thank everyone for all of their contributions. I do want to, I know we have to go, and I want to just encourage everyone to, go onto the website and try to look at the information, research the information, do your diligence, come up in your understanding and overstanding of law and lawful definitions, and then I think people will be less emotional. And that's all I really wanted to say at this time. I was a little bit distracted, everyone, because we got something going on in the backdrop, but I appreciate all of you. Thank you so much for coming on the call this evening, and everyone be safe, and just be, we will let you know once we have any other additional updates and any additional Zoom calls in the near future. So Mary Lou, you're a rock star. So thank you. Thank you for all of your help. Thank you, Coach Cola. Thank you, Neil, and have a great evening.
Thank you so much. Thank you, everyone. It's been an honor being here. Thank you. Good night.
Gracias.
Good night.
Good night, Coach Cola,
Thank
Mary
you.
Lou, Dino, Kim,
Good
all the
night,
leaders.
everyone.
We're
Thank you.
very happy to have you here. Colin
Thank
Fresh,
you.
everyone. Been an
Thank
honor. A good friend from down under, Australia, you know. I was thinking about the kangaroo while you were talking. It's all good, all right? We'll
Oh,
have good.
absolutely. And then, and on down under, just to piggyback on what Dino was saying, the gentleman, if we can get someone in that group, that would be great. With the Empowerment Project group, we need to contact them. If someone knows anyone, if they could please reach out to us, that would be great. So we can let them know what's actually going on.
Yeah,
That
because
would
the
be
guy that
wonderful.
was in charge of the Facebook group, we haven't heard from him for ages, and he was a personal friend of Linda Knox.
Oh,
So,
is that Keith?
eh?
Would that be Keith?
I think his name was Keith. Yeah.
Oh, wow. Yeah, because I've noticed it. Yeah. Okay. Okay. We haven't heard.
It's been inactive for about last month.
Right.
While on the call, I had a look and I couldn't even find it. So yeah. So I don't know
Okay.
what's going on there. Yeah.
Well, we'll definitely, we'll continue to reach out to them. I'm sure that somewhere along the lines, we'll be able to, the word will get out and we'll be able to contact them and give them an update. But, okay. Everyone have a
Okay.
wonderful evening. Thank you so
Yep,
much, all
okay.
of you. Thank you for
Bye.
coming.
Have a
this
nice
evening.
weekend for the Aussie.
Absolutely.
Yeah,
You as
bye.
well. You as well, sir.
Good night,
Be well.
everyone.
Good night.
Thank you
Good
for all
night.
you're doing. Appreciate it.